Hello and welcome. I am Mara Cepeda. This is Rappler Talk. We are here today with Cagayan de Oro Representative Rufus Rodriguez, who is one of the principal authors of the now controversial GCTA law. Hello, sir. Welcome to Rappler.
Hello, Mara. Thank you for coming in.
I'll just dive right into my questions, sir. What is the spirit and philosophy of the GCTA law back when you were drafting it as a bill? Is it about restorative justice?
The spirit of why we have House Bill 417, that is the origin, and which is now Section 1 of Republic Act 10592. The spirit is to be able to really comply with our penal system, which is not punitive, but it is reformative and rehabilitative. We want to give a chance to those who have been convicted to be able to have the benefits of the good conduct time allowance. And so our bill 417, which became Section 2, would now extend the benefits of the GCTA not only to convicted prisoners, which are the ones which were granted in the revised Penal Code of 1932, and so we will amend that to include those who have been arrested even before they are convicted, because it also takes time for the courts to convict, to acquit, or to convict. So therefore, for those who are arrested, this is now Section 1. We have now extended the benefits of the good conduct time allowance to these preventive prisoners. So that is the spirit, because we believe in the positivist view that we want to reform and rehabilitate our prisoners.
And it's a good premise for the law. But in the past weeks, sir, as you know, there are loopholes that have emerged in the GCTA law, and not just the legislation, but even the IRR, sir. And do you agree, sir, that the law was not explicit, at least if you look at the on the exclusion of the heinous crimes?
Although it is not explicit on Section 3, because our bill in the House was complete, which excluded 4 categories of prisoners, either detention prisoners. Number one is the recidivists, those who commit the same crime again. Habitual delinquents, those who commit 2 or more crimes. And third, escapees. And fourth, which is very, very important, is it excludes the good conduct time allowance cannot be granted to those charged with heinous crimes. And heinous crimes had been defined in the death penalty law, although the death penalty was subsequently lifted so that instead of death penalty, we will only have life imprisonment. Now, in those cases, we have piracy, we have treason, and then we have ito na ang mga more common to us, drugs, rape, murder, robbery with violence and intimidation, destructive arson, kidnapping with illegal detention. So yun ang excluded from the benefits of this Section 1. Now, you were saying precisely, the IRR, instead of the previous administrators harmonizing the law, because when you make implementing rules and regulation, when you draft that, you look at the entirety of the law. So it should have been harmonized. It would have been the ones who prepared and promulgated the IRR should have harmonized Section 1 with Section 3. How come na excluded yung heinous crimes sa preventive prisoners, and then it's not included, that the exclusion was not included on Section 3. And so therefore, this was not harmonized. So yung preventively imprisoned, they are excluded heinous crimes. Section 3, which came from the Senate, did not exclude heinous crimes. This is the cause of all the problems that we have.
So, sir, you're saying that the IRR, its lack of being explicit on the exclusion is the thing to be blamed about this whole fiasco over
yes,
the
the IRR did not harmonize the law by making also the exclusion in preventive prisoners are excluded from GCTA. They did not include it in the exclusion in the convicted prisoners.
So, sir, you agree with the ombudsman writing letters to then Interior Chief
I agree
Marrojas?
completely for the writing of letters, but I would say often that since our law, it can also be interpreted in that way by Secretary Rojas and Secretary De Lima, and I therefore believe that it was their judgment that when they issued those rules, they were in good faith.
Okay, so Secretary Rojas did make a Facebook post, sir, saying that they merely just follow the provisions of the law. So you're saying that the IRR is to be blamed, but can we also hold liable Secretary De Lima and Secretary Marrojas then, since they signed the
I couldn't
IRR?
agree. I couldn't make them liable, but it would have been a better IRR if both of them had harmonized Section 1 with Section 3.
Now, let's go into the Bucor officials, sir. So, yun sila ngayon yung pinag-iinitan, not just in the Senate hearing, but, even online, by the public. Who do you think among our prison officials should be held liable, sir?
The Bucor officials are clearly liable. Why? Granting that they follow the IRR, which did not include for convicted prisoners, yung exclusion sa GCTA. But after 2015, the law was passed in 2013. The IRR was in 2014. 2015, then Secretary Ben Caguioa of the Department of Justice issued Department Order 953. And there, it is already very clear that those who has a penalty of reclusion perpetua or life imprisonment, they should get the prior approval of the Secretary of Justice. And the Bucor officials they did not send any of the papers to the Secretary of Justice for the approval of the Secretary of Justice, even if these were cases involving a penalty of reclusion perpetua or life imprisonment. From that time on, there is a gross violation already by the Bucor officials. Sila lang. They were the only ones, secretly, because they were not published. These applicants were not published. The victims' families were just really shocked that they had already been released, those heinous crimes offenders. So, from the time on, since 2015 up to now, 2019, 4 years, that the violation of Bucor officials, and therefore I agree with Ombudsman Martires that these 30 officials of Bucor should be suspended preventively, 6 months preventive suspension without pay. And now they're being charged of grave misconduct, gross neglect of duty, and conduct prejudicial to the best interests of the service.
Let's go to Bucor Chief Nicanor Faeldon.
Yes.
Pinaka-mainit ngayon, sir. Were you satisfied with the way President Duterte fired him? Because after Faeldon was fired, the president still said that he trusted him. And this is a president who's really been going on a hardline stance against corruption and criminality. And then suddenly one of the officials under him, marami paulit-ulit na po yung mga anomalies, and not just in Bucor but in the different agencies po na pinalipat-lipat niya, sir.
I agreed with the president that he fired Faeldon, but I certainly disagree with the president when he said that he is an upright man. Indications, circumstances will show that when he was in the Bureau of Customs, large amounts of shabu, cocaine were disappeared from the bodegas. And here, what happened was he violated the order of the Secretary of Justice that he should send all these records of the life imprisonment penalty prisoners. It was just him who processed everything and ordered the release of these heinous crimes offenders.
Right now, sir, we are constrained to follow the definition of heinous crimes as stipulated by the death penalty law, like you said. And now we're now talking about proposed amendments to the GCTA law. How would you define, sir, heinous crimes now? Is it necessary to provide?
It is already defined in the death penalty law. Those are odious, grave in character. It's a menace to society. So, because of this heinous crimes law, we have already elevated these kinds of crimes into a category which is only found in the Philippines. There's no heinous crimes in other countries. Here in the Philippines, we have done that because especially because of the prevalence of drug, for example, drug trafficking. That is a heinous crime. And then rape and murder, which we abhor. And so therefore, that is already quite stated already, the heinous crimes law already provided for the nature of this kind of offenses.
And then there's no need, sir, to pass a separate legislation explicitly explaining what it is.
Or listing them down.
Yes.
It would be, yeah, there's some suggestion that we list down what is also in the heinous crime so that people in one glance reading the law will be complete. So we will put this up also, which are enumerated in the death penalty law.
Now, sir, you're working on a new bill proposing amendments to improve
That's
the law.
correct. We have here a proposed bill already. We are just trying to finalize this, and we still await the Senate investigation because things are coming out very fast on this. And so therefore, we are going to file, yes, an amendatory bill that will first make it clear, no ifs and buts. Two, it is comprehensive, so that it will guide all those involved in the implementation of Republic Act 10592.
Sir, one of the major amendments that you want to include is really to make an express standalone provision that heinous crimes are excluded
That's correct.
under the GCTA.
There will be a new section. What we have now in the present law is the exclusion of heinous crimes are only found in Section 1 on the preventive imprisoned persons. It is not found in convicted prisoners. It's not there. So we will remove from Section 1 that statement of exclusion and put it into a separate section which it would say that recidivists, habitual delinquents, escapees, and those charged with heinous crimes are not covered by this act. So the entire act from Section 1 to Section 6. So that will be stated in the amendatory law.
Sir, how about the issue on certain bad behaviors that should be disqualified completely from the GCTA?
We will also place there that aside from already excluding them, so they could not get this GCTA, the heinous crimes, how about those lesser than heinous crimes? They can always apply. Homicide, you know, those convicted of homicide. It does not have a death penalty and a life imprisonment for that. But aside from good behavior, they should not commit a crime while they're in prison, so that if they commit a crime, automatically there is no more good conduct for them. And then, number two, if they violate prison rules, on that month that they committed this infraction of prison rules, they will not be able to be given this 15 days, 17 days, that time, a good conduct time allowance.
Sir, yung sinasabi niyong pag-disqualify sa kanila when they commit a crime, is
Correct.
it just for that particular month or it's...
The entire na, because crime na yan eh. Iba yung you are violation of prison rules. So if you commit a crime, certainly you are already a recidivist in some sense because you're already in prison for a crime. You commit a crime, like you continue to have drug trafficking in prison. So that will disqualify you entirely from the coverage of this act.
And this would be a welcome amendment to many people who, were shocked of the reports when, rape, slay convict,
Yes.
former mayor of Calauan, Laguna, Antonio
Yes.
Sanchez would have been released.
Correct.
And there have been instances in the past na nakuhanan siya ng drugs. And,
That's correct.
Opo. And this is one
This
way.
will cover this kind of situation. So that, if you're already a prisoner, never do any other crime again. Because if you do that, you will be disqualified. In fact, if you do another crime, there'll be a hearing for that, and you'll be convicted for that another crime, the more you will stay in prison.
Now, sir, there is an ongoing argument that states that repeated offender of petty crimes, like halimbawa, nagnakaw lang sa sari-sari store, halimbawa, they shouldn't be lumped together with heinous crimes convicts.
I also agree. That's why there is a minimum, medium, and maximum security facilities, and that should have been done by our Bureau of Corrections officials. But because of lack also of resources, lack of budget given to them, so it's overcrowded already. Believe it. So mixed up na, and then those who can pay are given kubols, are given special cells. So that should not happen. So there has to be strictly, there has to be a minimum security, medium, at saka maximum. The maximum security prisoners should be in one group. They should not be mixed with those with petty crimes and the others. Yes.
Now, sir, you've been a long-time politician already and paulit-ulit na pong nababalita, na pag-uusapan yung issue po ng corruption sa loob ng lugar. Why is corruption still prevalent inside the New Bilibid prison?
In this case of the GCTA, it's because, you know, there was shall we say, there was no clear exclusion of the GCTA in the Section 3 for convicted prisoners. So immediately, these people immediately start receiving application from these heinous crimes offenders, and that gave the opportunity for them to demand money. So therefore, they gave money. Secondly, the Bureau of Correction is just really overcrowded, that it will be difficult to impose discipline. Just too many of them there in the Bilibid prison. And there are now what you call these prisoners who are, if there's a high valued, in other words, they are really drugs, they are really rapists. These big time prisoners have the resources. They can ask, they can pay that their cell phones be continued to be given to them and to operate the cell phones. And with this, they can continue with their crimes. Two, they can pay for special cells with air conditioning, with refrigerators and everything. They can now bring women, as already stated by the officials, and that is really a no-no. And then they can also pay hospital passes. Hospital for sale. So GCTA for sale, hospital for sale, and then entry of women and cell phones for sale.
So how do we make the law less prone to corruption if we know that, you know, there are circumstances within the prison itself that actually perpetuates this corrupt system?
First is a revamp of the leadership and even the mid-leadership of the Bucor. Let us start anew. But another bill I'm going to file is that we should already disperse the penitentiaries to our 16 regions. 4 regions already have penitentiaries. In Palawan, in Davao, in Mindoro, and in Zamboanga, there are now penitentiaries there. But 12 other regions do not. So that is why overcrowding here, and if it's overcrowded, it becomes, you know, a place where, you know, it's just like a marketplace, if you put it like that. So in a marketplace, you know, money changes hands. So if we are able to really disperse our prisoners to where the regions are, then certainly it will not be overcrowded. There's more focus on the officials there, and so it will be difficult for them to do business when everything is in order.
Sir, how much do you estimate that would cost the government having to build additional penitentiaries in different regions?
It could be a gradual basis to be able to. There are government lands in this region, so we don't have to buy the land. Then the building. Now, in America, there is no, in a maximum security, for example, facility, all of them are equally treated, the same number of square meters in the room. Okay, so nobody gets a special cell, unlike in our case, there's special kubol. So that is what we should do. So there has to be facilities for the maximum. It has been done, but it's not being followed there anymore, and believe it. So we'll have a minimum security, medium security, and maximum security. So probably then we have 3 buildings on that. So the buildings will have to be 3 floors that you can walk. Okay, so that's the most ideal. So 3 buildings, 3 floors each, then minimum, maximum, and then medium in regional centers.
But this proposal, sir, would cost the government a lot of money.
There will be, but we will make sure that you know, this is what we need, and so therefore government should provide for that, because our penal justice system has 5 pillars. First pillar is law enforcement, prosecution, and then we have the judges, and then the last is the penitentiary, the penal system of corrections. So all of this should be given funding, not only to the law enforcement should be given funding, to the prosecutors, to our judges, but we also have to give, therefore, to the community, to the correction side of the pillar of the justice system.
Would you push, sir, for the additional funds for more
I will
prison?
definitely will be filing this. I have filed a bill when I was in Congress. I will refile them again with more refinements already. That we are going to establish penitentiaries, national penitentiaries in the region. Can you imagine? Even from Tawi-Tawi, even from Apari, they have to be brought here to in Bilibid when they can stay in the region and be able to be there. And in fact, if you belong to your same region and the area is not in the prison is not overcrowded, the chance for reform, the chance of you getting a better insight of things will be better in the provinces than here in Bilibid, where it's really a rat race. So that is what it is. So I will certainly work for this bill that I will file for dispersing the penitentiaries to our 16 regions.
Aabot po ba to, sir, sa 2020 budget or baka 2021
Hindi na. So 2021 na. Kasi wala na. Tatapos na yung budget hearing namin ngayon. This coming Friday.
Sir, down to my last few questions.
Yes.
Now, was it illegal for the president to just order the rearrest of convicts who were freed under the GCTA?
The president is the president. But we are governed by the rule of law. Our country has a constitution. And the constitution provides that no person shall be deprived of life, liberty, or property without due process of law. Due process underlies the very, very tenet of our Bill of Rights. And that is why we have there, no person be deprived of liberty. That's why you cannot arrest anybody. It should be by a judicial officer, the judges, under another section of our Bill of Rights, that no person can be arrested unless there is a judicial determination of that there is a probable cause that a crime has been committed to be issued by a competent judge. So therefore, I believe that nobody can be rearrested again without going to court. And that has been decided in the case of People versus Fidel Tan by the Supreme Court, a 1967 case where Fidel Tan was released by the jail warden of the Leyte jail. And the prosecution filed a case filed a motion in the same case of origin for issuance of a warrant of arrest. Why? Because first, the jail warden has no authority to release. Only the director of prisons under that law at the time. And number two, there was wrongful computation. The jail warden deducted so much from the prisoner's time. And so the Supreme Court ruled that the court continues to have jurisdiction even after the final judgment, because even in the implementation of the release, the court still has jurisdiction. And so therefore, because of the motion of the prosecution to file a motion for the issuance of a warrant of arrest, the court issued a warrant of arrest. So this is the procedure which we're going to follow.
Pero sir, hindi po ito nangyayari ngayon. More about 500 GCTA freed convicts have surrendered themselves.
Yes, there is I think this fear by them. But as a lawyer, as a legislator, I would know that before you arrest a person without warrant, a person should be actually committing a crime, is about to commit a crime, has just committed a crime, or is an escapee without need of warrants of arrest. But these persons are not escapees. They walk through the front door. They have with them this release order signed by the Bucor head. And so therefore, how can we just treat them as escapees or those who should be rearrested again?
Yun na nga, sir. But a lot of these convicts, sir, like you said, natatakot po sila, and that's why they gave themselves up.
Yes.
Because the president himself said that they would be treated like fugitives.
And then at first, when they came back to the prisons, they had no food. They had no place to stay. They were put in the social hall. Why? Because they're already freed. The budget of the prison are for those prisoners who have not been released. So the more they suffered, these people who surrendered.
Paano yun, sir? Pag nag-surrender, if nag-surrender na sila, they can never go be free again under the GCTA?
So if they surrender, then they have to submit to the interpretation of the Department of Justice now that they are not covered because they are heinous crimes offenders. So they go back to jail and they will be jailed. But to me, the process is flawed because precisely they went there is no warrant of arrest. In fact, the prison officials should tell them to, oh, you have to go home because first, we cannot accept you in because you have not been rearrested properly.
Yung mga GCTA freed convicts, sir, is there a chance for them, lalo na pag, they really under the GCTA law provisions, dapat talaga papalayain sila, makakalaya pa po ba sila?
Well, precisely, some of these released prisoners who had been charged with heinous crimes, okay. Some of them, because 500 they surrendered, some of them will fight this in court, you see. So therefore, when they will be arrested, they will file a writ of habeas corpus. On the ground, there's no basis for their detention. This will go all the way to the Supreme Court.
Are you encouraging them to take it to court?
It is the right. I'm not encouraging them, but that is the right. And I have already read some lawyers already who are really of these released prisoners are waiting that they will be arrested without warrant, and then they will go because that is the policemen are there, so they will go. But at the same time, they will now file a petition for habeas corpus, and there, the judge, the RTC or the Supreme Court will now decide, one, is there a basis to rearrest them? Is the law clear? That is where it will be. So then the Supreme Court will say that either the law is clear, you go back because Section 1 applies to Section 3, or the Supreme Court will say, oh, the law is also very vague, so Section 1 is not applies to Section 3, so you go free. So these are the things that will be soon. This will be brought to the courts, I'm very sure.
Okay. Yeah. Sir, down to my last question.
You can have more questions.
Down to my last question for today. Ever since the whole issue about the GCTA law erupted, there are also renewed talks to revive the death penalty. Would you support the revival of the death penalty?
I am against the death penalty. But I have filed a bill for reciprocity. Death penalty for foreigners. Because our Filipinos, Filipinas in China, 2 or 3 were already executed for being drug mules. You remember that 4 years ago? Yeah. Also in Indonesia, we have now a pending execution of one Filipina there. And also in other parts, like in Singapore, yeah, there were also. So these are countries which have meted the death penalty for drugs, for example. Okay. Now, my bill, which is against death penalty for Filipinos, but because of reciprocity, if that country would execute our Filipinos, for example, for drug trafficking or other heinous crimes, if these Chinese also are here, conducting also illegal drugs operation here, and they are convicted, then we should give them also the death penalty, reciprocity. So that is what I have, but only for foreigners. Why? Because of our laxity here, because we do not have death penalty, all of these cartels, the Bamboo, the Triad, even the Medellin cartel of Mexico, are already here in the Philippines. Why? Because first, difficult to convict them because there's so many layers where they can use big money to free themselves. Now, if they are convicted, no death penalty. They continue to be in jail, and they continue to ply their trade through cell phones, through couriers, continue to conduct drug trafficking. So, therefore, it's about time that we send a message to the whole world that here in the Philippines, if your country has the death penalty here in the Philippines, foreigners who will use this as a base for drug trafficking will also be meted the death penalty by reciprocity.
How would you respond, sir, to critics who would say that, medyo Machiavellian tong proposal niyo, sir, eye for an eye, tooth for a tooth, and it might be discriminating against certain countries na foreigners lang?
We are trying to have the survival of our nation here at stake. And who are the big time drug traffickers here? Certainly, mostly the Chinese. We have no much capacity here to be manufacturing cocaine and shabu. That's why this comes from abroad, mainly China and Taiwan. And that's why they are brought here. And then there are the receivers here. The Chinese themselves are here, and many have been already arrested. So then many laboratories, shabu laboratories, have been discovered and arrested. Who are these people? Mostly Chinese. These are Chinese who are doing this. So therefore, that is what I'm saying, that if their country has death penalty for our Filipinos, we should have death penalty for them if they're here in the Philippines.
How will this affect, kaya, sir, our diplomatic relations with these countries?
No problem, because they have already death penalty for Filipinos in China. 2 or 3 have been executed there already. We cannot do anything about that. So they will also respect our sovereignty and our laws.
Mm-hmm. And that's all the time that we have now. Thank you so much, Kong Rufus.
Thank you very much. Thank you.
And there you have it. That was Cagayan de Oro Representative Rufus Rodriguez, one of the principal authors of the GCTA law, and he is going to be proposing amendments to the legislation that he helped write. This is Mara Cepeda, and this is just Rappler Talk. Join us again next time.